কোনো সমস্যা হচ্ছে চিকিৎসকের হয়রানি অথবা চিকিৎসকের মারধর করা হচ্ছে। এইভাবে এ ব্যাপারে প্রতিনিয়তই আমাদের বিভিন্ন আমাদের মানববন্ধন হচ্ছে। আমাদের মাঝে উপস্থিত আছেন ব্যারিস্টার তানজিবুল আলম, সিনিয়র অ্যাডভোকেট, সুপ্রিম কোর্ট অফ বাংলাদেশ। উনি একজন দক্ষ আইনজ্ঞ হিসেবে আপনি অবগত আছেন। বাংলাদেশ পেনাল কোড 18, নাথিং ইজ অফ an offense which is done by the accident or misfortune and without any criminal intention. এবং penal code 88 আছেন intended to cause death done by the consent in good faith for person's benefit. Nothing which not intended not to cause death is an offense by reason. এই চিকিৎসার ক্ষেত্রে দুর্ঘটনাজনিত মৃত্যু হলে নেগলিজেন্সি প্রমাণিত না হলে তা একটি অ্যাক্সিডেন্ট অর মিসফরচুন হিসাবে পরিগণিত হয়। আইনের আলোকে বিষয়টি আপনি কোন দৃষ্টিতে দেখেন?
ধন্যবাদ। I think if you were to discuss the legal issues and the implications for the current legal provisions that are prevailing and due to which none of us are satisfied, so we are looking for a solution. So before we look for solution, we need to understand what are the challenges that we are currently facing. So somewhere in a very scattered way, the discussion came in as far as the liability of a practitioner is concerned for providing any health service or diagnostic service, whatever we call it, can be twofold. One is the criminal liability, another is the civil liability. So I think most of our concern here is regarding the criminal liability. So the criminal liability is not confined to death alone. There could be criminal liability even for gross negligence by a doctor when someone is actually lost a limb or some part of the body because of negligence of the doctor during the operation, or for that matter even the diagnosis and providing the medical service. So the area is actually quite broad, and the way we are looking at what I gather from today's discussion is that we are looking at only from a very narrow perspective. So what we need to have is that we fix or determine what is the issue that we are trying to control or seek to address, and then actually open the discussion. So I will try to confine my discussion with regard to the criminal liability, but there could be situations where I would suggest that the doctors community can also come forward or talk about protections for or providing for the compensation in case of any professional negligence. In developed world, almost all the doctors, whoever is actually running a practice, is required to have insurance coverage. This is quite unfortunate that in Bangladesh we are lacking in that such a requirement. And the new legislation that has been proposed, I find this to be very sketchy and not actually thought after, or not providing any solution at all. This is very unfortunate on the part of the government, and for that matter even for the community as a whole, the doctors community as a whole, that they have not been able to. This is a golden opportunity, I believe, for the doctors community to bring in all the unresolved issue to actually also secure the standard of medical service as well as protection. There is a need for striking a right balance. If you look at it only, any provision of law only from the professional perspective, every doctor would like to see that no matter what they do, they are free from any sort of prosecution. This is what could be their perspective, but government cannot possibly afford that, to give that blanket protection, because government needs to deal with the recipient of the service as well. If tomorrow all the demands and the protection that the doctors community want through law is actually met, then there will be repercussion from the service receiver, saying that the doctors have been given a blanket sort of license to do whatever they like with their patient. So this is also not going to be sustainable, because whenever any legislation is framed, we need to consider both the service provider and the service recipient. In the draft act, there is no such commitment. I have noticed in the draft act that it is basically catering for the 15th Amendment judgment that we have been in all the enactments and the legislations by two successive martial law government has been declared unconstitutional, and all the ordinances or most of the ordinances have by now been given the legal effect through enactment of new legislation, and this is one of the remnant which has not been actually given effect to. So this is something we can always work on, and I'm happy to see that even of late the doctors communities are now engaging or thinking of consulting a lawyer, and I do not know why it has not been done long before. But what I see, if you look at the practical perspective or practical step that even the Bangladesh Surgeons Society can take, is that you should engage law professionals to give you the potential draft, and you provide the technical assistance to the government. All the time that you expect that the government will do your job and you do a bit of negotiation, lobbying that we want to insert one clause or the other clause. I think in the long term, this sort of ad hoc solution might not work in reality. What you should be doing as a society, if you are to really serve the community and give them protection, is that come up with some comprehensive draft, engaging good professionals, and then give it to the government, rather than trying to lobby from this corner to that corner. I believe the doctors community, or not only surgeons, even this entire community is quite strong as a community. So you do not necessarily need to lobby through pro-government organization, or for that matter. The BMDC could also play an important role. They have got the statutory authority in certain respect, particularly taking disciplinary action against the doctors for the professional negligence, maybe in respect of addressing the license. So this is something that we need to look at holistically. Now, addressing the issue about the tension between the media, public trial, and the harassment of doctors, no doubt, I'm sorry to say, in some respect, even the fellow doctors are also acting as a contributing factor. Just to give you one simple example, very recently you have seen that two fellow doctors of yours have been sent to jail, and they had to serve in jail before even any of the negligence has been established regarding the incident that took place in Central Hospital. And another doctor is being publicly vilified and put into a social media trial. In these circumstances, she is not even remotely present, even she was not in even the country when this particular incident, unfortunate incident took place. So what did we do as a lawyers community? Ask yourself, did any of you take any stand that how, or any of you thought rationally that, the publicly doctors are being humiliated, doctors are being put into media trial and now social media trial, and neither the ministry nor BMDC or any of the other organizations actually came forward to stand next to them. I mean, no doctor intentionally kills their patients. Absolutely impossible. And even law does not contemplate that such a situation that a doctor could be prosecuted for murder, not even manslaughter. It's actually negligence manslaughter. So homicide. So culpable homicide. So under that situation, what I see is that as a community, there is no common voice is coming forth. And this is also actually fueling the anger or giving the opportunity to actually grow unregulated or spreading of the misunderstanding among the consumers. That you have seen that many times with no fault of any doctors, a patient may die. But immediate rage is actually now befallen on the doctor who is in the immediate vicinity. And doctors community as a whole has not been standing unitedly for the protection of the doctors. So, as the saying goes, the charity must begin at home. If you are to actually seek any protections, please do not solely rely on the police force. Police would never keep their promises. With all due respect to the additional IG, he has basically admitted that we sometimes are compelled to arrest, knowing fully well that this arrest is unlawful. So, just to play the gallery show, I mean, why does it happen that patients or their relatives are seeking arrest of the doctor without understanding the complexity of it? In the proposed act, there is a requirement has been introduced that no law or no criminal FIR would be accepted or admitted without accompanied by a medical report or by a panel of three doctors who would be actually giving a report, investigation report, that there has indeed been primary evidence of negligence and leading to death. I think this is something that also need to be thought through and also examined in the context of the current reality, that whether this sort of professions can also give you adequate protection or not. And there are huge level of, very high level of frustration among the service recipient or the patients, that they do not get proper service from their doctors, and the emotions of a relative immediately after actually knowing that his dear ones has died, and he sees connects the dot between the death and the presence of the doctor. So most of the time these take care of that, and the law is absolutely inadequate. But I think this is something that we have to live with in terms of raising the public sentiment or controlling the public sentiment, and so to speak. So I do not see any alternative to a comprehensive approach. I'm glad to see that the ministry has actually taken actually a pause to reflect on the draft act, and this is something that improvement of the current draft is something that the community as a whole can take, and of course without the help of expert lawyers, it is perhaps not going to give you any good result. So with these few remarks, I would like to thank the society for inviting me today and giving me the opportunity. I know everybody is very busy, but this is something that is actually not only for the protection of the lawyers, the doctors community. I think it is also for the protection of the medical sector as a whole, and also in the larger picture, the citizens of the country as a whole. Thank you.